how much differentiation is needed to avoid patent infringement. And I will say patent rights are governed by what's written in the claims. For a utility patent, it's what the extent and the scope of the written claims. On the design side, it's what's in solid black line. What's shown in that drawing is the three-dimensional article. What you've got to do, let's say on the utility side, to avoid infringement, hire an attorney to help you. Okay, but read the claims. If you're able to discern, what an attorney would advise you to do is they'd read through the claims, looking at the broadest claims possible, which are usually the independent claims, and break it out element by element. And so long as you are not meeting one of those elements, you're not infringing. And so that kind of goes to say the more detailed a claim in general, the more specific it is, and the easier it is to avoid infringement. Anything else to add to that, David?
Just starts me thinking about how you're drafting them in the first place with those sorts of strategies in mind, right? We keep talking about, well, there's a lot of this stuff we can do by ourselves, right? As individual inventors or business owners trying to protect their trademarks. Absolutely. There's so much of this that you can do yourself. And JD, you and I can sit here and answer question after question after question and answer all of this stuff. We'll give away all of this information and knowledge. There's no way we can take anybody to law school. It's just not going to happen, right? So like you mentioned before, the issue spotting, but also partnering with somebody to get strategic about what you're trying to do. How should we draft these things? It's like the same thing in trademarks. Like, what is the description of the goods and services that I'm providing? And how do, as I add more, it gets more specific, it can. And then it's maybe that much easier for somebody who might be using something confusingly similar to say, yeah, but mine's enough different, I'm enough different that it's a different market. It's a different reasonable purchaser, that relevant purchasing public is a different group, or it's in a different channel, or these kinds of things to try and avoid that infringement. So you don't really want to open too many doors for folks.
Totally.
You can avoid that.
Yes.
But sometimes you have to get pretty specific and narrow because you're trying to thread the needle between this cool patent and that cool patent. It's like, no, my stuff's right here. It's right here. So sometimes you kind of boxed in, and you really do have to get specific. And that's what you need to do. And again, that's the guidance part.
Yeah, totally. The strategy, you nailed it. Yeah, it's not just that question. Your goal is to avoid being sued to begin with, right? You don't want to have to go through, even if you're right on the merits. You don't want to be so close, if you can, that it would even come up. So there's a lot of different scenarios and the practical advice that you can get when you hire an attorney that's used to looking at this sort of stuff.